Good evening. How's everybody doing? Great to be learning with you on a Thursday, Yom Hamishi. Let's light up the darkness. And truly, it is nighttime here in LA. So it's Yom Shishi, the sixth day, Erev Shabbos. And for that reason, it is the yard site of the Alter Rebbe. So the Alter Rebbe, Rabbi Shneur Zalman of Liadi, is the founder of Chabad Hasidism. And it's interesting. I mean, very few Hasidic guys more famous than the Alter Rebbe. And there was always, in the early days of the Hasidic movement, the kind of a tension, some would say not only in the early days, between the Hasidim and the Litvaks, right? So the Litvaks, known, to really prioritize education over everything. The center of learning for them was in Vilna, the great Talmudic center of Torah learning in Europe. And the idea that the Hasidic movement founded by the Baal Shem Tov, and he was the start, and then the Maggid of Mezrich was the next generation, and then his students, including the Alter Rebbe, were the founders of various Hasidic dynasties, that third generation after the Baal Shem Tov. And the idea that the Hasidim were all about ecstatic prayer, and that even the simple Jew could come very close to God, to Hashem, and that somehow, the learning of the Talmudists, of the Litvaks, was not as esteemed by them, was really a misnomer, more or less a slander against the Hasidim, because while it was true that they said that the prayers and devotion of simple Jews is very close to Hashem, they were not saying that Torah learning is to be diminished or neglected in any way. And the Alter Rebbe himself authored a Shulchan Aruch, right? A code of Jewish law, the Shulchan Aruch Harav, and took halacha and Torah learning extremely seriously. And he was actually called, kind of endearingly within the Lubavitch world, the Litvak. They called him the Litvak, I guess because he had spent time in Vilna and was so learned. And I'm sure that people in the Chabad movement could do much better, more justice to the story than I can. But at any rate, his yard site is today. And the movement that he created, Chabad, as sort of brought to a whole new level by the Rebbe, meaning the Lubavitcher Rebbe of blessed memory, the seventh Rebbe of Chabad. The Alter Rebbe was the first. The Lubavitcher Rebbe, Rabbi Menachem Mendel Schneerson, who passed away in 94 or 95, I can't remember right now. But he really took it to such another level by sending the shluchim, his emissaries, around the world, and making it possible for a Jew, almost no matter where he is in the world, to connect with authentic Judaism and Yiddishkeit through that, series of Chabad houses, Chabad synagogues all over the world, and essentially taking Judaism to where the Jews are without watering it down at all. So it's amazing what Chabad has done. It's amazing what Chabad has been since it was created, and we honor the Alter Rebbe. We dedicate our learning to him today, and we certainly want to honor him, and may his neshama have, an aliyah at the highest levels of heaven. May his soul be at the highest levels of heaven. But also, when we learn in honor of the Alter Rebbe on his yard site, he has such a strong spiritual power. It may just lift up our learning a little bit. Perhaps we will see things even a little bit more clearly tonight as we sort of plug into his beautiful Torah learning and energy and love and devotion to the Jewish people and to Torah around the world. And it's great timing because we are starting a new chapter here in Tractate Sanhedrin. 24th volume of the Talmud. Our daf tonight is page 32. We're opening chapter 4. And this chapter is a spectacular chapter. We're on page 32. When we get to page 37, God willing, next week, that's one of the great addresses of, mind-blowing teachings in the Talmud. Sanhedrin 37 has some stories on it that I've been telling over, for years. Really incredible stuff. And this whole chapter is amazing. So beautiful that we're opening it on the yard site, the anniversary of the passing of the Alter Rebbe. Okay. Just welcoming Melissa in Great Neck, Stephen in New Hampshire, Guy in Ohio, Yehuda in South Carolina, Joe in the Inland Empire, Karen in Northern California, Lucy in Minnesota, Renee in Indiana, Lorraine in Texas, Bella in Texas, Sharon in New Jersey, Bella in Florida. And Renee says, Kenya Hirat son, so may it be the will of God that our learning be elevated in this way. And Chaim in Florida, Marjorie in Georgia, Ella in Southern California, Frank in San Pedro, Elanit in Silver Spring, Marie in Freeport, and Alan in New York City. Welcome, everybody. Mickey says, Shalom, everyone. It was 2 degrees Fahrenheit in Vineland this morning. I feel for you, my brother. I feel for you. May you be warm, and may our Torah learning warm you up even a little more. Okay, page 32 here in Tractate Sanhedrin, 24th volume of the Talmud, opening chapter 4, Mishnah number 1. Both cases of monetary law and cases of capital law are equal with regard to the requirement for inquiry and interrogation of the witnesses. And the distinction between inquiry and interrogation posed to the witnesses will be discussed at greater length in chapter 5. We're now in chapter 4. That's not really what this Mishnah is about, right? So with respect to monetary law and capital cases, we have to, examine the witnesses very carefully. Later we'll talk about what is the difference between inquiry and interrogation. And why are they equal before capital law and monetary law? Because, says the Torah, Leviticus 24:22, you shall have one manner of law. Having stated the essential similarity between cases of monetary law and cases of capital law, right? Money changing hands or a defendant on trial for his life because of a crime that he committed. Now we ask, what are the differences between these kinds of cases? Cases of monetary law are judged by a court of 3 judges, as we learned in Mishna number 1 of this tractate. And cases of capital law are judged by a court of 23 judges, as we learned in that same Mishnah. In cases of monetary law, the court opens the deliberations either with a claim to exempt the accused or with a claim to find him liable. And in cases of capital law, the court opens the deliberations, right, after they've heard all the witness testimony and when the judges begin their deliberations. And in cases of capital law, the court opens the deliberations with a claim to acquit the accused, but it does not open the deliberations with a claim to find him liable. As we will see over and over and over again, in a capital case, the court will try everything to avoid executing the defendant. It's going to have to be such a certain case against him for a court to actually execute. And that's why we'll learn later in this tractate that a court that executes more than once in 70 years is called a murderous court, right? A bloodthirsty court. So it's really very difficult to condemn a defendant to execution. And this is one of the ways in which we see that when they begin their deliberations, they might start with a claim that will acquit the defendant, but they won't start with a claim that would condemn him to be executed. In cases of monetary law, the court directs, meaning issues, the ruling based on a majority of one judge, for example, 2-1, either to exempt or to find liable. But in cases of capital law, the court directs the judgment based on a majority of 1 to acquit. It could be 12 versus 11 to acquit. But you need a majority of at least 2 judges to find him liable. right? So you would need it to be at least 13 to 10 before you could convict. In cases of monetary law, the court brings the accused back to be judged again if new evidence arises, either with a claim to exempt the accused or with a claim to find him liable. But in cases of capital law, the court brings the accused back to be judged again with a claim to acquit him, but the court does not bring him back to be judged with a claim to find him liable. In other words, no double jeopardy. If he was acquitted of a capital crime, he won't be brought back to stand trial for it again. If he was convicted and they find exonerating evidence, they will bring him back. In cases of monetary law, all those present at the trial may teach a reason to exempt a litigant or to find him liable. In cases of capital law, all those present at the trial may teach a reason to acquit the accused, but not all present may teach a reason to find him liable. Only the judges can teach a reason to find him liable. In cases of monetary law, one who initially teaches a reason to find the accused liable may then teach a reason to exempt him. And one who initially reaches a reason to exempt him may then teach a reason to find him liable. In cases of capital law, one who initially teaches a reason to find him liable may then teach a reason to acquit. But one who initially teaches a reason to acquit may not turn around and teach a reason to find him liable. In cases of monetary law, the court judges during the daytime and may conclude the deliberations and issue the ruling even at night. In cases of capital law, the court judges during the daytime and concludes the deliberations and issues the ruling only in the daytime. In cases of monetary law, the court may conclude the deliberations and issue the ruling even on that same day, whether to exempt the accused or to find him liable to pay, because it's a monetary law case. But in cases of capital law, the court may conclude the deliberations and issue the ruling even on the same day to acquit the accused, but must wait until the following day to convict him. Therefore, since capital cases might continue for 2 days, the court does not judge cases of capital law on certain days, neither on Erev Shabbos, where we are now, right, Friday, nor the eve of a festival. In cases of monetary law and likewise in cases of ritual impurity and purity, the judges commence expressing their opinions from the greatest of the judges. In cases of capital law, the judges commence issuing their opinions from the side, i.e., where the least significant judges sit. And finally, all are fit to judge cases of monetary law, but not all are fit to judge cases of capital law. And here we're not talking about how learned they are. We're actually talking about heredity. Meaning, only priests, Levites, and Israelites who are of sufficiently fit lineage to marry their daughters, priests or Levites, and only Israelites who are of sufficiently fit lineage to marry their daughters to members of the priesthood are fit to judge cases of capital law. And this means that mamzers, converts, and disqualified priests themselves, a halal priest whose daughter is not fit to marry a priest, none of these would be qualified to sit as judges in a capital law case. That is the Mishna, number 1 here in chapter 4, now the Gemara. The Mishna teaches that cases of monetary law require inquiry and interrogation of the witnesses. So the Gemara asks, do we require inquiry and interrogation in cases of monetary law? And the Gemara raises a contradiction from a Baraisa. So keep in mind, the Mishna said that both in capital law cases and monetary law cases, the court, examines the witnesses very carefully using, questions of inquiry and questions of interrogation. Like I said, we'll learn more about that in chapter 5, but the point is they grill the witnesses. And so now, so that's what the Mishnah said. And now the Gemara is going to raise a contradiction to that from a Baraisa, right? Baraisa is generally contemporaneous with, but a little less authoritative than Mishnayos. Okay, so the Gemara raises a contradiction from a Baraisa in the Tosefta of Tractate Makos 1:2. So with regard to a promissory note, whose date is written on the 1st of Nisan of the sabbatical year, and witnesses came and said to the signatory witnesses, right? So other witnesses came and said to the people who signed their names as witnesses on this promissory note that was dated on the 1st of Nisan in a Shemitah year, a sabbatical year. Why is a sabbatical year significant? Because in a sabbatical year, at the end of the year, all debts are canceled. So this would indicate that somebody lent money with a promissory note close to the end of the period, at that 7-year cycle, where by the end of that year, any debt, if the borrower had not paid it back, he won't ever have to pay it back, right? So it's unusual for a promissory note to be written at such a time. But here we have a promissory note that was dated at that time, and there were 2 witnesses signed on it. And now come these other 2 witnesses and say, and these other witnesses come and say to the signatory witnesses, how is it that you are testifying concerning this promissory note that you signed? But is it not so that on such and such a day on which the promissory note was written, you are with us in such and such a place, meaning somewhere else than where this promissory note was signed? You said you signed it on the 1st of Nisan in the sabbatical year. Well, we know that on the 1st of Nisan in that sabbatical year, you were with us in another city. So you must be a liar. You must have signed that promissory note fraudulently. So what's going on? The promissory, in that case, the promissory note is nevertheless valid. Why? And its witnesses remain fit to bear witnesses. We don't say that they have committed fraud and therefore we're never going to believe them again if they appear as witnesses. Why? If they were somewhere else on the day that it is alleged that they signed this promissory note, well, the reason that they are not proven to have signed that promissory note falsely is that we are concerned that perhaps they delayed and wrote it. Meaning, the loan was given on an earlier date and the promissory note was postdated. So the Gemara explains the contradiction. And if it enters your mind to say that we require inquiry and interrogation in cases of monetary law, how are we concerned that perhaps they delayed and wrote it? The signatory witnesses would be asked on which day they signed the promissory note, and when that does not accord with what is written in the promissory note, their testimony would be disregarded. So sounds like we would have found that out easily through an inquiry and interrogation, but since it wasn't found out in that manner, it must be that inquiry and interrogation are not done for witnesses in a monetary law case. So the Gemara explains, and if it enters your mind to say that we require inquiry and interrogation in cases of monetary law, how are we concerned that perhaps they delayed and wrote it? The signatory witnesses would be asked when they did it. It would come out during that inquiry and interrogation. And since they wrote it on a day that's not the day that it was dated on the document itself, we would just disregard what was written there. We would disregard this promissory note since there's something false about it. So the Gemara counters, and according to your reasoning that we do not require inquiry and interrogation in cases of monetary law, the Mishnah elsewhere should pose a difficulty for you as well, as Mishnayos are more authoritative than Baraisas. So it is preferable to raise a contradiction between 2 Mishnayos than to raise a contradiction from a Baraisa to a Mishnah. And the Mishnah teaches in Tractate Shevit 10:5, antedated promissory notes are not valid, but postdated promissory notes are valid, right? You can sign today, and we're going to write a date on this promissory note, 2 months from now. And that's okay. And if it enters your mind to say that we require interrogation and inquiry and interrogation in cases of monetary law, and that if there is a contradiction, the testimony is not accepted, well then, why are postdated promissory notes valid? The witness's testimony does not accord with what is written in the document. So the Gemara finally explains, La Kasha, this is not difficult. There is a reason why the contradiction was raised from the Baraisa and not from this other Mishnah. We are saying a better, meaning a stronger contradiction than the one from that other Mishnah. As one sees in the Baraisa that even with regard to a promissory note written on the 1st of Nisan in the sabbatical year, when it is not common to find people to lend money, as all debts are canceled at the close of the sabbatical year, where it is not as reasonable to say that perhaps they delayed and wrote the promissory note, as one would not damage his promissory note by postdating it so close to the end of the sabbatical year. Even so, since the sabbatical year cancels debts only at its close, meaning at the end of that year, we are concerned that the promissory note was postdated, and therefore we deem it valid. And this is why the contradiction was raised from the Baraisa and not from the Mishnah. Now, the Gemara returns to its question. In any case, the contradiction between the Mishnah and the Baraisa is difficult. The Gemara now presents a mnemonic device for the following discussion, with each letter representing the name of a sage who suggests an answer to our dilemma. Hes, Reish, Pei, Shin. First one is Rabbi Chanina, Ches. So the Gemara cites the first answer. Rabbi Chanina says, by Torah law, both cases of monetary law and cases of capital law are equal with regard to inquiry and interrogation of witnesses. As it is stated, you shall have one manner of law. So according to Torah law, we should grill witnesses in the same thorough manner, whether it's a case of monetary law or a case of capital law. Now, instinctively, we understand capital law case is more important, to be very thorough, because if the defendant is convicted, he's going to be executed. In a monetary law case, if you make a mistake, okay, the defendant has to pay money. You could always get the money back later. Nevertheless, the Torah says you shall have one manner of law. So the same way you interrogate witnesses in capital law cases, you should be interrogating them in monetary law cases. And what is the reason that the sages said that in cases of monetary law, we do not need inquiry and interrogation? It is an ordinance instituted by the sages so as not to lock the door in the face of potential borrowers. The sages were concerned that intensive examination of the witnesses would often result in contradictory testimony and render it difficult for lenders to collect their debts. And this could lead to people refraining from lending money. We don't have the authority in this very late period in Jewish history, after 3,500 years of history, to change Torah law. But the sages had much more authority. They were much closer to the giving of Torah, right? They were operating 1,500 to 2,000 years ago. And society, in the wake of the destruction of the Second Temple, and they were creating a kind of portable Torah-based Judaism rather than a Holy Temple-based Judaism. It was Torah-based before, but now in the absence of the Holy Temple and bringing sacrifices to Jerusalem, etc., they were able to issue certain kinds of decrees based on policy considerations for the protection of the people. Right? So what they're saying here is, okay, we can relax this evidentiary laws with respect to, these kinds of much more commonplace cases with a much lower threshold. The stakes are much lower. But the stakes are high for poor people who need to borrow money in order to survive. So we don't want to have barriers to these people being able to get the money. Remember, when they were borrowing money from another Jew, it was prohibited for the lender to charge interest. So the lender is only doing it to do a righteous and kind thing for the benefit of the borrower. But they need to have some protection that they're going to be paid back, right? They're not being asked to give charity, to just give the money away. The arrangement is a loan, and they have to have some certainty that they're going to be paid back. So if you're going to make it too difficult, and where if the witnesses don't agree with anything, the lender is not going to be able to, get paid back by the borrower, it's going to be much harder to find people who are willing to lend to the poor. And so they, in light of the way things were in that society at that time, they issued this decree that we're not going to grill witnesses in quite the same way for these monetary law cases as we would for capital law cases. And the Gemara asks, well, if that is so, that the sages remove the requirement for inquiry and interrogation in cases of monetary law, then if the judges erred, they should not need to pay the party that they wronged, right? If they made an error of law in applying the law, we've seen that in certain kinds of cases, if the judge made a mistake and found the defendant liable to pay money when he shouldn't have, the judge is going to have to make restitution and make it good. That's not in all cases, but in some. So for those kinds of cases where that sort of restitution would be applicable, if you're saying, yeah, but the sages removed the requirement for interrogation and for inquiry and interrogation, well, then why should that judge have to pay? He didn't have access to the best possible information when he went about making his decision. So if he made a mistake, he should be excused on those grounds. And the Gemara answers, if you were to excuse judges in this way, all the more so that would lock the door on the face of potential borrowers. If people know that the courts are not responsible for an error in judgment, they will not be willing to lend money. Now we're on page 32b. Rava says the ruling of the Mishna here that cases of monetary law require inquiry and interrogation is stated with regard to laws of fines, not standard cases of monetary law. And the other sources, i.e. the Mishna and Tractate Shavit and the Baraisa, which do not require inquiry and interrogation, this is stated with regard to cases of admissions and loans in which there is cause to relax the procedures of deliberation, as we just explained. The difference being cases of fines, right? Torah imposed fines, like the double payment of the thief or the half payment of the innocent ox that had not gored before. These are special cases in the Torah, and as we said yesterday, only sages at the level of sages were qualified to adjudicate such cases. And so we're going to be, in those kinds of cases, we're going to be much more careful, and the inquiry interrogation would be permitted. Rav Papa says this and that, i.e., both the Mishnah here and those other sources are stated with regard to cases of admission and loan, meaning typical monetary law cases. And the distinction between them is that the Mishnah here, which rules that cases of monetary law do require inquiry and interrogation of the witnesses, this is stated with regard to a possibly fraudulent trial. What's that? Where the court suspects that one party is attempting to defraud the other party and have witnesses offer false testimony on his own behalf. There, in the Baraisa and in the Mishna and Tractate Shavit, which do not require inquiry and interrogation, the ruling is stated with regard to a trial that does not appear fraudulent. Right? So if a judge has reason to believe that something fishy is going on, then he will use all the tools at his disposal of inquiry and interrogation to basically try and trip up the witness. That's what we're talking about. Inquiry and interrogation is where the judge is like really grilling the witness and trying to trip him up. It's almost like, El Al Securities asking you questions. How long are you staying here? Who are you staying with? Do you know people there? When did you last see them? When did you last speak to them? Does your friend have friends in America? Does your friends in America know your friends in Israel? And they keep asking you questions, and they're trying to get you to contradict yourself so they can catch you if you are lying. But it's also, people get nervous, and sometimes they make mistakes, not because they're lying, but just because they're nervous. And that's where that's inquiry and interrogation could trip up a witness and cause the plaintiff to lose his case. Now, if there's a reason to suspect somebody's lying, they will engage all these tools of inquiry and interrogation. But if it's a more typical case where a guy comes in, he says, yeah, I mean, I saw Reuven lend Shimon the money, and I was there and I saw it. You don't have, and I swear I'm telling the truth. They certainly adjure him, or you wouldn't say I swear I'm telling the truth, but they certainly adjure him that if you are lying here in a court of law, you will have sinned for all time. And that will certainly impress on the witnesses the need to tell the truth. But in terms of grilling them and trying to trip them up, we see we don't need that in the standard monetary law case. Now, the distinction, this distinction is in accordance with the statement of Reish Lakish, as Reish Lakish raises a contradiction between two verses in the Torah. It is written in one verse, in justice shall you judge your neighbor. That's Leviticus 19:15. And it is written in another verse in Deuteronomy 16:21, tzedek, tzedek, right? Tzedek, tzedek, tirduf, justice, justice shall you pursue. And the repetition of this very famous line in the Torah, it doesn't say justice shall you pursue, it says justice, justice shall you pursue. And we've had many, many sages and rabbis over the centuries interpret why this word is repeated. Kind of very classic teaching. I forget who said it first. Tzedek, tzedek, justice, justice means that when you are pursuing justice, you will do so with justice. That you don't break the law or set the law aside or trample people's rights in order to get to a just result. The process of arriving at justice has to be just itself. That's one classic teaching. What are we learning here? Justice, justice shall you pursue. And here they're interpreting the repetition as indicating that it is not enough to merely judge with justice. So what does that mean? So how can these texts be reconciled? Here, this latter verse is stated with regard to a possibly fraudulent trial, where the court must take extra care to judge with justice. And there, that former verse is stated with regard to a trial that does not appear fraudulent, right? Where it does not appear fraudulent, right, then in justice shall you judge your neighbor, meaning give your neighbor the benefit of the doubt. But when you have reason to doubt your neighbor, then you turn the screws and really examine the matter as carefully as necessary in order to see if he's lying or not. Rav Ashi says, the ruling of the Mishna here, that cases of monetary law require inquiry and interrogation, is as we answered, i.e. in accordance with any one of the answers offered by the other Amoraim, the sages of the Gemara. And those verses were not stated with regard to fraudulent trials. Rather, says Rav Ashi, one is stated with regard to judgment, in which case the court must pursue justice extensively, and the other is stated with regard to compromise. Rav Ashi is saying, if the case is going to go all the way to a verdict, yeah, you're going to have to use inquiry and interrogation to really grill the witnesses. But if the parties are willing to compromise, like arbitration, then you don't have to grill the witnesses quite so thoroughly. And it's better to have a compromise. Everyone walks away satisfied and at peace. But if they can't reach a compromise, then you have to grill everyone thoroughly. That's what Rav Ashi says. As it is taught in a Baraisa, when the verse states, tzedek, tzedek, tirduv, tzedek, tzedek shall you pursue, one mention of justice is stated with regard to judgment, right, reaching a verdict. And one is stated with regard to compromise, right? Before the judges issue a verdict, the parties are willing to compromise. How so? And here, very example, they're not being, this sounds like a metaphor, but actually they're saying these could be real cases. How so? Where there are two boats traveling on the river, and they encounter each other. So in a narrow spot of the river. So if both of them attempt to pass, both of them sink. Right? It's too narrow, they can't get through. If they both try to get through, they're going to crash and sink. If they pass one after the other, So then both of them pass. And similarly, when there are two camels who are ascending the ascent of Beit Horon, where there is a narrow, steep path and they encounter each other, both of them attempt to ascend, both of them fall. If they ascend one after the other, both of them ascend. Okay? So in other words, if they conflict, they're both going down. If they work together on this, reach a compromise, then they both survive. So the nature of this compromise is that one of them is going to go first. And the one that goes first is going to reach its destination first. And therefore is going to have some kind of, financial advantage that the one who was caused to wait is going to arrive there later. And it's like, it's going to cost him time and money to arrive late. So which of the parties should be caused to have some damages, should be caused to be a little bit late and suffer some kind of a damage? Which one? Right? How are we going? Both of them are saying, no, I need to get there first. I need to get there first. But we have to reach some kind of a compromise. So how are we going to adjudicate such a situation? How does one decide which of them should go first? If there is one boat that is laden, right, it's carrying cargo, and the other boat is not laden with cargo, okay, so the needs of the one that is not laden should be overridden due to the needs of the one that is laden. One of them has cargo. They need to get to where they're going. If there is one boat that is close to its destination and one boat that is not close to its destination, so the one that is close, the needs of the one that is close should be overridden due to the needs of the one that is not close. Which I think is interesting because if one is close, then he's expected quite soon. And if he has to wait till I'll let the other one pass, his lateness is going to be more significant. But they're saying no. At the end of the day, whichever one has to wait is going to be that much behind schedule, whether it arrives tomorrow or next week. And we say that the one that's farther away from its destination, its needs are prioritized. Now, if both of them were equally close to their destinations, or both of them were equally far from their destinations, then you impose a compromise between them to decide which one goes first. And the owners of the boats pay a fee to one another. Meaning, the owners of the boat that goes first compensate the owner of the boat that waits for any loss incurred. Okay, so we're going to make one go first, but he's going to compensate the other, and so that compromise should satisfy both. Now, the sages taught, the verse states, tzedek, tzedek, tirdof, justice, justice shall you pursue. And this teaches that one should follow the best, most prestigious court of the generation, right? Totally different interpretation of what the verse means in the Torah. It means that you need to go to the best possible court with the smartest, most learned judges who are most likely to produce a true verdict according to Torah law. So, for example, follow after Rabbi Eliezer to Lod, or after Rabban Yochanan ben Zakkai to Beror Chayil, right? Those are the Gedolim, the great judges, the great sages of their generation. If you have a difficult case, go to them. The sages taught when the Gentile authorities issued decrees outlawing observance of the commandments, members of Jewish communities devised clandestine ways of indicating observance of commandments to each other. So, for example, if one produces the sound of a millstone in the city of Burni, this is tantamount to announcing Week of the Sun, S-O-N, meaning there will be a bris, there will be a circumcision this week. Right? So, in other words, if the Romans were oppressing the Jews and saying, or the Greeks did this kind of thing especially, you are not permitted to circumcise your children. Well, they're not going to listen to those authorities, even though it's dangerous. So they can't communicate, hey, I'm having a bris in my house next week, everybody come, because then the authorities will find out about it. So they had secret signals like this. And if one displays the light of a lamp in the city called Beror Chayil, this is tantamount to announcing that there is a wedding feast there. There is a wedding feast there. The sages taught. The verse states, tzedek, tzedek, tirdof. So now a new meaning of this phrase. This teaches that one should follow the sages to the academy where they are found. For example, follow after Rabbi Eliezer to Lod, after Rabban Yochanan ben Zakkai to Beror Chayil, after Rabbi Yehoshua to Pekin, and Rabban Gamliel to Yavne, and Rabbi Kiba to Bnei Barak, and Rabbi Mattia to Rome, and Rabbi Hanania ben Teradion to Sikne, and after Rabbi Yosei to Sippori, and Rabbi Yehuda ben Betera to Netzivim, and after Rabbi Yehoshua to the exile, meaning to Bavel, and after Rebbe, meaning Rabbi Yehuda Hanasi, to Beit Sharim, and after the sages in the time of the temple, to the chamber of hewn stone, meaning go see the Sanhedrin at the Holy Temple in Jerusalem when the temple is standing. New subject. The Mishnah teaches that in cases of monetary law, the court opens the deliberations either with a claim to exempt the accused or with a claim to find him liable, right? When they've heard all the witness testimony and considered the evidence, now the judges are going to open their deliberations, and whichever one of them speaks first, he could start with his argument to convict, or rather to hold the defendant liable, or to find the defendant exempt. He could start either way in the deliberations. In cases of capital law, the court opens the deliberations with a claim to acquit the accused, but does not open the deliberations with a claim to find him liable. Right? So if we're going to have a capital case where the defendant is on trial for his life, he could be executed, then the first argument that has to be made in the deliberations is a reason to acquit him and find him innocent. And the Gemara asks, how do we say this opening stage of the deliberations? In other words, with what claim does the court begin deliberating? And Rav Yehuda said, we say this to the witnesses. Who says that the event occurred as you said? Perhaps you erred. And Ula said to him, well, but by confronting the witnesses in this manner, we silence them. The witnesses will think that the court suspects them of lying, and they will not testify. So Rav Yehuda said to him, and let them be silenced. Isn't it taught in a Baraisa, Tosefta 9:1, that Rabbi Shimon ben Eliezer says in cases of capital law, the court brings the witnesses from one place to another place in order to confuse them, so that they will retract their testimony if they are lying. Again, grilling the witnesses, trying to confuse them and to trip them up, if it's a capital law case. So if that's the case, why not pressure them and start by saying, I think you lied, or maybe you lied. Are you sure you're telling the truth? And the Gemara rejects this argument. Are these laws comparable? There, where Rabbi Shimon ben Eliezer says to bring the witnesses from place to place, the witnesses are repressed by themselves. They might, become flustered that they're being brought from one place to another. But we're not accusing them of doing something wrong. We're just taking them from one place to another. But here, we repress them by direct action, accusing them of being liars. And that a court should not do. So rather, that's not how we open. And Ula says, we say this to the accused. Do you have witnesses to determine that the witnesses who testified against you are conspiring witnesses? Right? These witnesses have shown that you committed murder, for example. Do you have witnesses that can show that these witnesses are liars and that they couldn't have seen what they said they saw because they were actually somewhere else on that day? And Rabbah said to him, but do we open the deliberations with a claim to acquit the accused that is to the liability of someone else, i.e. the witnesses? Right? If indeed the witnesses are found to be conspiring witnesses, well, they might stand to be executed. If they are conspiring witnesses in a capital law case, and if their testimony was accepted, the defendant would be executed, and then they're found to be conspiring witnesses, then they are subject to be executed. So if we open our deliberations with that, isn't it tantamount to opening with a claim to convict somebody, not the accused, but these conspiring witnesses? Doesn't sound like what we want to do. So the Gemara says, but is this to the liability of the witnesses? But didn't we learn in a Mishna that conspiring witnesses are not killed for their testimony until the verdict of the one concerning whom they testified is issued? Meaning, if before the verdict against the accused is delivered, right? These two witnesses came and they said, we saw this guy commit murder. And then he's convicted of the murder. And then new witnesses come in and say, oh, those witnesses lied. We know that they couldn't have seen what they said they saw because they were with us in this other city. So then the conspiring witnesses would be liable to be executed because their testimony resulted in a conviction of the accused. Whereas, if those witnesses came and said, we saw, Joe commit murder at this place at this time, and then before the verdict was delivered against the accused, these other witnesses came and revealed that the first witnesses are conspiring witnesses. Since the verdict was never issued that would condemn Joe to be executed, the witnesses that were shown to be false, they are now conspiring witnesses. They are disqualified from ever giving testimony again, but they're not liable to the death penalty because their testimony did not result in Joe being convicted, in other words, receiving a guilty verdict from the court. So that's the difference between whether the second witnesses arrive before or after the verdict is given. And so that's why he's saying here, since the witnesses arrive before the verdict is given, well, it's not going to create the situation where the conspiring witnesses are liable to the death penalty. So why not open with this, claim to exonerate the accused as just the first claim to be considered during the deliberations of the judges? So the Gemara rejects this argument. Are these laws comparable? There, where Rabbi Shimon ben Elazar says to bring, and the Gemara restates Rabbah's objection. This is what, wait a minute. Therefore, So the Gemara restates Rabbah's objection. This is what I say. If the accused would be silent until his verdict is issued, and then brings witnesses, and the court determines them to be conspiring witnesses, it will be found that the statement of the court is to the liability of this one, the witnesses. In other words, we have the possibility that the second set of witnesses who find the first set of witnesses to be conspiring witnesses, that won't be revealed until after the verdict is given, and therefore the first set of witnesses would be liable to the death penalty, and therefore we should not open with such a claim as the first stage of the deliberations of the courts. And somebody could die from that. That's not a good place to start. So, rather, Rabbah says, we say to the accused, do you have witnesses to contradict the witnesses against you? If the first witnesses are contradicted as to the facts of the case, then no one is liable. That's not rendering the first witnesses conspiring witnesses. They're just saying, I have witnesses that saw it differently. That's just a contradictory testimony. And if we have two sets of witnesses offering contradictory testimony, the facts are not clear and the defendant will not be executed. I'm almost done. Questions or comments, please get them in now. Rav Kahana said, we say to the witnesses, based on your statements, so-and-so is acquitted. Wait, what? We just heard all the evidence. Now the judges are going to begin their deliberations. We don't know what the verdict is yet. According to Rav Kahana, the first thing the judges say is to the witnesses, based on your statements, so-and-so is acquitted. This testimony is not sufficient to convict. Even if it is sufficient to convict, we say it's not. Why would we do that? The court issues this pro forma declaration that it is possible to find a reason to acquit based on the testimony of the witnesses. And then they begin the deliberations. And Abaya and Rava both say, we say to the accused, for example, if you did not kill anyone, do not fear the consequences of these proceedings, as you will be acquitted. Rav Ashi says, the court announces whoever knows of a reason to acquit the accused should come and teach this reason concerning him. Now we see that there was not one regular custom of how to open the proceedings. Seems like different courts had different ways of doing it, but all of them were basically starting the deliberations with a sort of desire to acquit, at least in capital law cases, and we understand why. And the Gemara comments, it is taught in the Baraisa in accordance with the explanation of Abaye and Rava. And Rebbe says the priest administering the sota, right, to the sota, says to her, right, this is the case in the Torah, the law of the suspected adulteress, the woman who was warned by her husband, do not sequester yourself, do not be in a room alone with that particular man, because, people think that you might be cheating on me with him. And so the husband warns her not to ever be alone in a room with that man. And then witnesses see that she does sequester herself in a room alone with that man. At that point, she becomes a sota, a suspected adulteress. And when the temple is standing, she and her husband now become prohibited to each other. They can just divorce, or if she claims she's innocent, they can go to Jerusalem, to the temple, and go through the ritual of the sota, in which she drinks the bitter waters. It's just water with a little bit of dirt in it from the floor of the temple. And the words of the verses that describe this procedure, written on a parchment, and then the ink dissolves into the water. There's nothing poisonous or dangerous about it. So if she's innocent and she drinks that water, she'll be fine. And in fact, if she was infertile before, she will become fertile. But if she did cheat on her husband, then it's like God will intervene. She'll drink those waters, and she'll die. Right. So that's the what's the word I'm looking for? Not just the ritual, but the test. What's that word? Where you go through something difficult. Somebody will give it to me. So where you go through that, and when they go through that ritual at the Holy Temple, the Kohen, the priest in the temple, first opens that ritual by saying to her, if no man has lain with you, and if you have not gone astray to impurity while under the authority of your husband, you shall be free from this water of bitterness that causes the curse. You'll be fine. If you're innocent, you'll be fine. But if you have gone astray while under the authority of your husband, then you will die. So take this seriously, and please don't drink this water if you actually cheated on him, because nobody here wants to see you die. Why don't you just admit it? You'll be divorced. You'll be done. And from here, it is derived that in cases of capital law, the court opens the deliberations by first raising a claim to acquit the accused. And this baraisa corresponds to the explanation of Abaye and Rava that the court notifies the accused that he has nothing to fear if he is innocent. We're at the top of page 33a. We'll knock off there. Tomorrow, we'll continue on Friday, the regular Friday time in winter. Shabbat still comes in pretty early, so it'll be 11:30 a.m. Pacific. Renee, with respect to tzedek, justice, I carried a medallion with that teaching throughout my career, and now it sits on my desk. I think, meaning the specific teaching that you shall pursue justice in a just manner, right? Beautiful. Bill, I would suspect the reason the farther boat goes before the nearer boat is that the longer journey is the one more likely to have further delays and misadventures. A great idea. And it is essentially an attempt to reduce Murphy's Law, that anything that can go wrong will go wrong. I like it. Sharon, it disturbs me that there is an attempt to disturb or fluster a witness. It definitely impacts a less confident or secure person rather than a more sophisticated individual. Yeah. And that's why in standard cases, right, 99% of cases, we don't do that. But in a capital law case, which is not going to be very typical, we do that because we're just looking for any out to not have to execute this person. Now, if you're the family of a murder victim, you might not like this very much. And the word I couldn't think of, thank you, Bill, ordeal. That's exactly the word I was looking for. Thank you so much. And that's what I have got. My document is stuck. Bill also says, as in trial by, notable that the soter ritual is... Wait a minute. Sorry, my document skipped. Notable that the soter ritual is the only trial by ordeal in the Torah. They're much more common in pagan traditions, and in many ways, one of the things the Torah did is to try and wean humanity off that nonsense. Not that even the soter ritual is an... I think you said not, but it should be note. That even the soter ritual is an inverted trial by ordeal. It's easier to survive and to be declared innocent than to fail and be declared guilty. Right. If she sinks, she's a witch. No, sorry. If she sinks, she's innocent. Whatever. Right. Usually it was really bad. They had one right in Monty Python, the Holy Grail, where the typical outcome... Right. What Bill is saying is that in the pagan rituals, if she drank regular water and she survived, she's a witch and we burn her. Right. But of course, the Torah says, no, if she drinks just water with a little bit of dirt in it, she's innocent. And survives that, she's innocent. If she, dies from drinking water with a little bit of dirt in it, it's because she was guilty. So the more expected outcome would be to survive and be innocent. That's what I've got for us today, and with God's help, we'll be together tomorrow, Friday, regular Friday time, 11:30 a.m. Pacific. Have a great night.